The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 4 cases will be submitted this afternoon. Those cases are Jacob Schmidt versus State of Iowa versus Stephen Jonas. Third case is Jason Cannon versus Bodensteiner Implement Company. And the final case is in the matter of the estate of Margaret E. Workman. The last 2 cases are now submitted to the court without argument, and we'll now hear the arguments in Schmidt versus State of Iowa. Ms. Lucy.
May it please the court. Hello, I'm Martha Lucy, and I'm here representing Mr. Schmidt. Again, I guess I'll say. A person who has material facts previously not heard is entitled to an opportunity to present that evidence in a hearing. Erroneous convictions, whether they're from a guilty plea or from a trial, result in the same constitutional defect. The criminal justice system may have a guilty plea problem. If guilty pleas are not subject to any type of review with evidence of actual innocence, credible, reliable evidence, then we have a problem and the Constitution is offended. This court has the opportunity to either confirm that process through a post-conviction relief or a PCR, or has the ability to establish that process, and I think that may be what brings us here today. I would submit to this court that if you are only looking at Mr. Schmidt's case, the existing process that is available works. Iowa Code Section 822.2 would allow for the exception for the statute of limitations in Mr. Schmidt's case, and 822.11D would certainly provide a ground for him to raise this in post-conviction. If you're looking at the fact that this may not qualify under those 2 tests, then this court does need to go farther and say whether or not the Iowa Constitution provides a means for challenging wrongful convictions. Or erroneous convictions, however you want to phrase it. I think there's different terms of art, and I apologize if I intermix them. I think one of the hardest questions the court has is, what is the test that you're going to apply in this type of case? If we're going to deal with a trial, the existing test and Moore certainly works, with one exception. If Moore requires that the new evidence be newly discovered, again, term of art, newly discovered evidence, then there may be a difficulty, because Iowa Code Section 822 only provides that it be material facts not previously presented and heard. The court has always interpreted that to be the newly discovered evidence test for a motion for new trial. I would submit to you that there are instances where a litigant may not be able to meet that test, but has credible, reliable evidence of innocence.
What would let's assume you won the hearing that you're requesting. What would the record be for the PCR court at that hearing? What evidence could they consider the minutes of testimony that describe what the stepfather's testimony would have been on this trial that never happened, for example?
And I think that's where we sort of run into a little bit of difficulty. I think the court can consider the minutes of testimony as it exists, what the state of the record was when Mr. Schmidt decided to enter the guilty plea. I don't think that the court can necessarily consider those untested minutes to be truthful or accurate. Because if so, then they also have to say that BC's proposed testimony is truthful and accurate, and his recantation is what? I don't know. So, I mean, I think that's the difficulty. But I think that the minutes have to be part of the record because the district court needs to look at the record as a whole. Mr. Schmidt would have the burden of proof. If those minutes, and I think the sticking point really in this case is whether or not the stepfather would have the same testimony.
Here's my trouble with this, and maybe you can help me out. You know, the standard for someone being found guilty or innocent in a court of law is whether or not the state can prove you guilty beyond a reasonable doubt. And when a defendant is faced with that evidence, he or she makes a decision, well, I may take a deal because although I may not have done it, I can get a better deal because all the evidence is stacked against me. So if you just apply that, it makes sense that, you know, if you get newly discovered evidence to make that, you know, that would affect that decision, maybe the guilty plea is no good. But the other side of the coin is, and this is what bothers me, in order for our courts to accept a guilty plea, you have to have a factual basis, and you basically have to admit you did the crime.
Kind of.
Well, you do. You have to admit that. Well, that's what I want to know. So you're
Okay.
kind of maybe is the answer. So
I think the
tell me
answer is-
where my logic is
Okay.
wrong.
I think the difficulty is that it's a kinda. One, it could be an Alford plea, or what, you know, other states call it different things, where the defendant is specifically not admitting.
But this wasn't an Alford plea, was
This
it?
was not.
No.
But you also have those other situations where they may recite the elements with.
There's substantial evidence to support each element, isn't
Yeah.
that what you plead
Well,
to?
and that's the deal. And on review, that's what this court is looking at. Is there substantial evidence on the element? But you have to admit that there's cases where the minutes say something completely different. And the court will say, for example, and was the amount of damage over $1,000? And nothing in the record says yes
But
to that.
my-
And the defendant says yes.
My problem is, though, is when you have somebody who has overwhelming evidence of their guilt and they didn't do it, and that happens. We know
Sure.
that happens. The defendant says, I basically did it. He doesn't say, the evidence is overwhelming, then I'll be convicted. He says, I did A, B, C, and D for the factual basis.
Right.
And so, does our system just force people to lie?
Yes.
Well, here the court asked Mr. Schmidt, I need to have you tell me in your own words what you did that makes you think you are guilty of this charge. Defendant, I performed a sex act on a minor child. Where's the kinda in that?
There's no detail. That's one of the elements to incest is that, and he didn't have to do the minor in that one.
Well, the detail that came out was, and that he was your half-brother and all that. I think the detail's in the colloquy. With the colloquy, the transcript of the guilty plea hearing, I assume that's something the PCR court could use.
Yes,
Okay. And if there was ultimately a new trial, that would be part of the trial.
it would not be part of the project.
No? Okay.
One, it's not under oath. And I don't think that at a new trial, anybody should get to say, oh, he previously entered a plea of guilty. Otherwise,
what
you're
this
not going to have a new trial.
I'd like to build on what's being discussed here, and that is, what is this hearing? Assuming you get through to the courthouse to get a hearing. I'd like you to explore with me, what does a hearing look like? And what is the evidence that comes in? And then ultimately, of course, what's the standard? But so I take it we have a recantation of the victim in this case, at least.
Correct.
And then the key question is it credible? Is it not credible?
You have to be determined.
It has to be determined. The defendant testimony of the victim that he recanted and so forth. And then what does the state do? What kind of evidence do they put on? I mean, do they call the stepfather to the stand? What does this hearing look like?
Well, I think the hearing, what it looks like, will really kind of depend on what eventual test this court picks. But in general, and are we talking about this case or
Well, let's
general
talk about
case?
this case.
Okay.
Yeah.
So if I were representing the applicant, I would probably want to present testimony of of BC and certainly find out what that's all about. I think that potentially the testimony from Mr. Schmidt would be important as to his reasons for entering a guilty plea was, whether, it was the evidence stacked against him, whether it was the guarantee that it wasn't going to be 35 years in prison and a lifetime special sentence, whether, those types of issues. And then, if you look at the minutes with the police report, he denied it when confronted. He said, I didn't do it.
Okay, then what does this,
Stepdad's lying.
what does
So,
the state's case look like then?
if I were representing the state, I hate to give them their case, but I would be able to put on evidence of, I would probably want stepdad's audio tape from the police or the police squad car, if it still exists. I would want the tape from BC's interview.
About the stepdad himself?
Sure, but if you can authenticate that video,
He gets on the stand, he says, you know what?
I'll remember.
This is what I saw.
Sure, and I was starting at the low end. I would call the stepdad. I would probably, from the petitioner's side, I think certainly maybe defense counsel, maybe, don't know.
And then what is the standard that gets applied? Let's say, let's play it through a little bit, and the victim stands strong on the recantation, says no, says, in fact, and I'm just gonna, this is all hypothetical, but supposing he says, well, stepdad didn't see what he thinks he saw something different, and yeah, he did kind of breeze by, but he was terribly mistaken, blah, blah, blah. Stepdad gets on the stand and says, well, I guess maybe I'm not 100% sure, whatever. But what is the standard then? I mean, what's the level of proof? It's going to be somewhat high, I think. But push back at me.
I guess, again, it depends on what this court decides as far
Well,
as.
tell us what you think.
If it is a post-conviction relief hearing, the standard is preponderance of evidence. That
Proving what
is-
by preponderance? Proving by a preponderance of evidence that,
There's a reasonable likelihood he would not have entered the guilty plea. I mean, that's my proposed test. But for, if he
Can't
had
say
known the evidence.
yeah. And I can't say I saw that in any of the cases. I found about, I think maybe 15 guilty plea jurisdictions. Maybe there's more. I don't know. I mean, I can't say that I exhausted, but I found quite a few.
Yeah.
And none of them go off in that direction, I don't think.
I don't think that they do either, and I'll be honest, when I was trying to research and write this, I couldn't find cases that really were helping me. And I
Why-
compared
why-
to the Brady. That's where I got the test from.
I mean, why would the state ever take a guilty plea under your approach? I mean, really, you make it easier to set aside a guilty plea than a conviction after trial. And at least when there's been a trial, you have the testimony. If the witnesses aren't available, you can reuse the old testimony and things like that. What would be the point of taking a plea?
From the state's perspective, they can't try all these cases. And that's why we may have a guilty plea problem. From the state's perspective, there's no way.
From your perspective, would we have to have a mini trial or a PCR trial anytime there's a recantation by a victim?
If it passes,
After a conviction based on a guilty plea?
if it passes summary judgment, yes.
All right, so you wouldn't have a trial if it's just a collateral witness who recants. It might be material, might not be material. Would that require a hearing? I'm just curious. We have a victim here. And the interesting thing about a victim is if what the victim says is true and it's a unequivocal recantation, then your client's not guilty, of course.
Right.
But
Which
there's all
was
kinds of
a
other
big
kinds of
concern.
yeah, but, is it only you're entitled to get through the door if it's the victim recanting, or?
Well, I think that because we're dealing with a recantation, we're hung up on recantation. I think that if you look at evidence in general, if it survives summary judgment, then they're entitled to a hearing. If it doesn't survive summary judgment, then they're not.
Under our existing precedent, wasn't the trial court correct to just apply the legal effect of the guilty plea and grant summary judgment dismissing this PCR?
I would submit no, because nothing in the PCR statute says that you can't do PCR from a guilty plea. And if it did, then think about this. The DNA statute allows for testing for a guilty plea, but there's no remedy. How does that work? And there has to be some remedy from a guilty plea if it is factually incorrect. And I'll go back to Justice Wiggins, may I sum up? He said that at a trial we are found beyond reasonable doubt guilty or innocent. No, we're found guilty or not guilty. The innocence is a totally different animal. And I would ask that you give my client a hearing. Thank you.
Thank you as well, Ms. Lucy. Ms. Solich.
Good afternoon, Your Honors. May it please the Court. Your Honors, my argument here today will be somewhat layered, but my first argument needs to be that the state is absolutely not conceding that the guilty plea constitutes a waiver. And to respond to Justice Waterman's question, the trial court, the post-conviction court, was absolutely correct under existing precedent, under Alexander, under Matley. Well, Alexander has that odd dicta, but we'll say Matley, Antonucci, Speed, all of those cases where this court has said time and time again, a guilty plea is a waiver of all defenses not intrinsic to the plea.
Well, what about the research that Schmidt's brief puts out about that, there's a lot of people that plead guilty even when they're not? What do we do with that?
Your Honor, I would say, first of all, that the exonerations, I think the level of exonerations vary depending on what study you look at and what is truly an exoneration. And if we're counting exonerations as interfamily child sex abuse recantations, that clearly should not, in the state's view, be considered as an actual exoneration. But we would assume that some people do plead guilty without actually being guilty. I'm sure that does occur, unfortunately. And as long as there is some...
Well, it pleads guilty without doing the crime. I mean, guilt is a function of the United States Constitution. Prove each element beyond a reasonable doubt. That's
Yes,
what
sir.
guilt or innocence is, but actually doing it or not doing it is a separate matter. And that's, as Justice Katie says, that's where the problem comes.
But, Your Honor, we allow Alford pleas every day. We allow defendants to maintain their innocence and say, I did not commit this crime, but the state could prove it if it would go to trial, so I am going to take a guilty plea, and that is not any kind of constitutional violation. We allow that.
If this kid took a Alford plea, then we'd have a different situation.
I don't think we would have an entirely different situation, Your Honor, and that is because at the end of the day, the Alford plea is the same as any other guilty plea. I can see why defendants would want to take Alford pleas. It may allow them to save face with their family or their friends, but at the end of the day, again, that defendant is just as convicted, considered just as convicted as any other defendant who has pled guilty. So I would say that in terms of the legal consequences of an Alford plea versus a regular plea, they are the same.
But I agree, they're guilty, but did they do it? Should someone be in jail if they didn't do it? That's the question we have to answer.
Your Honor, we would hope someone would not be in jail or prison if they didn't commit the crime, but the fact of the matter is I think the system cannot be perfect. We can try.
Oh, yes, but if someone makes a compelling showing of actual innocence, we can't regard them as systemic roadkill. I mean.
No, no,
It
Your
would
Honor.
shock the conscience. I mean, if you had a case, plea bargain or not, where someone makes a compelling case of actual innocence, oftentimes DNA, but not necessarily. Surely, holding someone in prison for the remainder of their life, let's just say, for a crime they demonstrably did not commit would cause constitutional problems,
But
plea
a crime
bargain
that
or
they
not.
admitted, I'm sorry, Your Honor, a
Even
crime
if
they
they admitted.
committing, though.
Even if they admitted earlier, if the evidence is compelling that they did not do the crime. Now, I think for me, quite frankly, the more interesting question is one of standard, and it is absolutely correct, of course. I mean, just functionally correct that when you have a plea bargain, you have a lesser record than when you have a full-blown trial, and works. So the standard that might apply to a full-blown trial, maybe it doesn't fit comfortably. I mean, maybe it fits, but whatever. So the suggestion is that the better standard on plea bargain, where there's plea bargain is, well, you attack the nature of the plea bargain.
Which I absolutely disagree with, Your Honor.
And I
if may.
understand that. I'm inviting you to explore that with
I
us.
think that's practically no standard at all, to allow a defendant to say, well, I would have pled guilty, or I'm sorry, I would have gone to trial rather than have pled guilty had my little brother, let's say, come forward and recanted earlier, really doesn't give the defendant anything that he really has to prove. And it seems ironic to me that if we're going to think in terms of actual innocence, that we would have a standard that doesn't require the defendant to even remotely try to prove his actual innocence. So if we're going to have an actual innocence standard, we need to, at the very least, have that be the focus. But I'd like to walk the court back, if I might, and first argue that this court doesn't need to reach the actual innocence question. Because if the court is concerned, and I know the court is concerned about an innocent person languishing in prison who pleaded guilty, but now newly discovered evidence has come to light establishing his innocence, this court clearly can change the law with regard to newly discovered evidence and the post-conviction statute. So if Your Honors decide that guilty plea defendants should be treated in the same way as defendants who chose to go to trial for purposes of post-conviction, which is what, of course, this defendant argues, that the statute says any person and there should be no distinction, then, Your Honors, that defendant simply proceeds under 822(2)(1)D, the newly discovered evidence provision. That provision, of course, provides that if there is evidence of material facts not previously presented and heard that require the vacation of the conviction in the interest of justice, then the defendant may present that claim in PCR. So all this court really needs to do is to say, if it, again, the state would ask you not to say this, but that ship may have sailed, so to the extent that the court is inclined to protect guilty plea defendants in just the same way that they protect other defendants, you could say post-conviction relief chapter applies to everyone. Then the court, of course, just enacts or applies a newly discovered evidence test. Would it be the Moore case? It could be the Moore case. It could be one of the cases the state cites in its supplemental brief where courts have wrestled with the exact issue of guilty pleas and newly discovered evidence claims. There are, I think, 3 cases in the brief. Schneider is the Colorado case where the court basically uses a newly discovered evidence test looking at did the evidence exist, was there due diligence, but they also put in a question, does this newly discovered evidence show that the charges are false or unfounded? That's the question that court, the Colorado Supreme Court, uses. And then they have the 4th element of our Moore test, Harrington test, but they tweak it just a bit and they say, would this new evidence show that a new trial, there would be an acquittal in a trial, I'm sorry, not a new trial, because there's not a trial. Would the evidence show, so that's kind of a 4-part test that the court has fashioned in Colorado.
If we
Yes, Your Honor.
applied that test, what outcome in this case?
Your Honor, I think under any test, frankly, this defendant cannot
hearing.
But, Your Honor, as we discussed at the beginning of this, under the current case law, the trial court was under no obligation to give him a hearing.
And I'm not sure that's right, because here you have the victim unequivocally stating that this crime did not occur. Now, for purposes of the simple motion, we take it as true if it's supported by affidavit. If it is true that the crime didn't occur, then he'd be entitled to relief. Now, I surely understand that the state intends to contest that and says, well, it's not credible because, you know, he testified at trial, or he at least offered a different view earlier, et cetera, and we have all this other evidence. And then, after a hearing, you prevail, but at the current stage where a victim offers an unequivocal recantation, don't you have to have a hearing to determine what you've got?
Your Honor, I don't think you do, or you did maybe until after today, but I really think in the state of the law, when this was tried, all the trial court was faced with was a recantation, which we all know is viewed with extreme suspicion.
But that's
and-
a concept, I'm sorry to interrupt you, but
No,
if you
go
don't
ahead,
mind.
Your
Yeah,
Honor.
but that's a concept of evidence. And you look at all the cases that talk about extreme skepticism, they're all in the context of a hearing.
Right, but then we overlay onto that the idea that a guilty plea defendant has waived all of his defenses. So my point,
Back up on that, because, all right, let's say hypothetically, this case went to trial, and the people who were listed in the minutes of testimony testified consistent with what's in the minutes, and Schmidt was convicted, went to prison, and then this recantation came along in a PCR. Would the district court have to hold a hearing?
no.
Yeah, and then why should the standard be different with a guilty plea?
Why wouldn't you have to hold a hearing if you had a recantation? The hearing you had was already, the trial proceeded beforehand.
With the
And so you have a full record. Here, we don't have a full record.
But, Your Honor, again, we have a recantation and only a recantation, and even on this record, we have other evidence disputing the recantation.
And that needs to be offered at the hearing to undermine the truth of the affidavit that's asserted. I mean, I can imagine, and I was asking her hypotheticals, but at a hearing, if such a hearing occurred in this case, the state would want to put on the stepfather's testimony and probably the tape and I don't know what all else. And most of the cases that I read, if there's conflicting testimony, you know, relief isn't granted, even under a fairly low standard of actual innocence. On the other hand, if the stars lined up and the stepdad gets on the stand and says, well, you know, I mean, we're just speaking hypothetically here, but the point is, she's entitled to a hearing when her affidavit that she submitted does offer a complete defense.
And again, if it were a trial, that would absolutely be true. But I hate to keep repeating this same answer, but the reason that the court in this case did not grant the hearing is because the court said, you pled guilty, you were
Lid
not
on the
entitled
box
to the.
theory, I understand that.
Okay, but isn't that rule exist based on the logic that if you plead guilty, you must be guilty? And aren't we learning that that's not necessarily true anymore? So as a justice system, shouldn't we start to re-examine rules that might show imperfections?
Your Honor, as a justice system, though, in Iowa, we have several safeguards that other courts do not have. We do have the factual basis requirement. We have the 8-2B colloquy, which was extensive in this case. The plea transcript and sentencing transcript is 39 pages. That, to me, seemed long. The court took its time, discussed everything with this defendant. We have, of course, most importantly, the idea that you can always challenge the plea at the back end with a claim that it's involuntary or unknowing. So we have different sorts of protections for people who choose to plead guilty. And if they choose to plead guilty, shouldn't we take them at their word that they are guilty when they make this solemn statement in front of a judge? Now, again, there may be a few that are not guilty factually.
Well, I think it's, we say a few. I mean, I don't know when you might be alarmed by that, but The research is out there that shows that people do plead guilty when they're not.
That's true,
And
Your Honor.
and we have a process now that essentially, the court can just grant summary judgment and not go any further into the case.
Which is why, if this court puts guilty plea defendants on the same ground as defendants who have chosen to go to trial, then at least the court's concerns would be addressed. Because really, other than a newly discovered evidence claim, there's not going to be any situation, I think, where a defendant, I suppose, in the scheme of things, someone could just out of the blue say, I'm innocent, I have no newly discovered evidence to show it, I have no constitutional complaint about my guilty plea, but I'm innocent. And I would just urge the court very quickly to reject the defendant's suggestion in the supplemental brief that you actually look at that first 822.21A provision that says any violation of the Constitution, and the defendant has argued, if I'm innocent and I'm in prison, that's a violation of the Constitution. Therefore, I get to make an actual innocence claim, and no statute of limitations should apply to me. We talked about the floodgates last time, I think, with Justice Hecht. This would be astronomical in terms of floodgates if we would
How
allow.
often do you have a victim recanting in a sexual abuse case, a victim recanting in a child sexual abuse case?
Frequently, Your Honor.
And you ought to have arguably hearings to determine the veracity of it. Let me ask you a hypothetical, though. Supposing, in addition to the affidavit that they have, BC, they had an affidavit from the stepfather, and the stepfather said in the affidavit, I lied. In fact, there were family dynamics involved. You know, I'm a stepfather, there's romantic issues, dysfunctional household, and I wanted to retaliate against this guy and get him out of the household, and had such an affidavit, along with the affidavit from BC. But he pled guilty and admitted everything. What would your view under that record be?
Well, my view under the old law would be, no matter what, the lid on the box. I know this court is
Oh my,
not.
really?
Yeah, Your Honor, that is the case law for even in Herrera, I'm sorry, Your Honor, may I finish my answer? Even in Herrera, where a Texas prisoner was going to be put to death and came forward 10 years later and said, I am actually innocent, the court said, as long as there is some avenue for redress, and in that case they said clemency, as long as there's some even small avenue for redress, the Constitution does not require that we take every step in every way to make sure that every defendant can continually.
You as a prosecutor would say, even though there's overwhelming evidence of that you're not guilty, the system requires that you spend your prison time because you pled guilty.
Your Honor, if there's overwhelming evidence that you're not guilty, that's when the clemency comes in. That's when the request to the executive branch, or, and if I might,
Or go see somebody else. So as a prosecutor, you've convicted.
Your Honor, I'm sorry. You could go see this court, I think, if you wanted to reach the exception that you talked about in Grissom. I'm sorry to bring something substantive when I'm out of time, but State v. Grissom in '97, Justice Cady, I believe you wrote that case, and you said that you will make an exception, the court will make an exception, if a newly discovered evidence claim is not quite meeting all four characteristics or all four criteria, when there is an utter failure of justice, or it would be unjust to enforce. So again, I think that doesn't happen very often. I've not really seen it happen since, but the court in that case, the woman said she had hepatitis C. She wanted to be released. This court said, you have other options, the Board of Parole, but importantly, Your Honors, if you want to not send it to someone else, but you want to keep it within your own confines, this court in Grissom did say we can use this exception when there would be an utter failure of justice. Thank you.
Thank you as well, counsel. Rebuttal, Ms. Lucy?
I would urge this court that whatever standard of proof, whatever quantum of proof you choose, one, that it should comport with post-conviction relief. because that is the only means that we have for these litigants to go back into court. We don't have habeas corpus. We don't have another proceeding. So first, I would urge you to continue with the preponderance of the evidence standard, and if you're successful, that it's a new trial. If you decide that that's not the proper route to go, I would urge you to use whatever standard and quantum of proof and then a corresponding remedy. If it is affirmative, whatever the state's test of affirmative that he's not guilty, it shouldn't be a new trial. It should be an acquittal, which means that we've turned the PCR court into an ultimate determination of guilt or innocence, and true innocence.
If we applied the Schlupp test, what outcome, in your view?
I think the difficulty with the Schlupp test is that it's a two-parter. And the first part is only to get through the gateway. And I would urge that we don't have a gateway. We have a direct means. And in that case, what I would be really concerned about in practice, that gateway is credibility determinations without the ability to have a hearing. It's not summary judgment. It is actual determinations that, I don't think you're telling the truth, so never mind. The second part is that it requires a constitutional violation. It depends on whether we as society and whether this court, with your authority, is going to decide that incarceration or punishment of an actual innocent is a constitutional violation. In the federal courts, that's not the case.
Well, let's pursue Schlupp a little different, from a different angle. As I understand it, though, the operating standard would be that no one could find the defendant guilty beyond a reasonable doubt. No reasonable juror, if you will, could find guilt beyond a reasonable doubt. What's wrong with that standard?
It's still a probability, so it's really not much different. It's the probability that,
Well, no reasonable juror might be a pretty high test for you.
but it's still a probability standard. So, and under Schlupp, the standard of proof is probability. It's not clear and convincing.
But couldn't the PCR court, on summary judgment, in light of the guilty plea, in light of the presumed testimony of the stepfather as an eyewitness, say, hey, a reasonable juror could convict based on, well, just based on the stepdad's presumed testimony alone, summary judgment?
And then we get into the difficulty of a reasonable juror. In our existing way of doing things means if the state presented evidence on an element. So you don't have any credibility determination at that point, because a reasonable juror could say that stepdad's more credible than BC. Another reasonable juror could say BC's more credible than stepdad. So we're going into this credibility weighing.
These tests, would you look at what BC would have testified to back then? Would that be the test under these hypothetical tests?
Well, I think that you look at the record as a whole, and so that would be, what was the proposed
Could
testimony?
the state have obtained a conviction based on what BC would have testified to back then and the step-parent?
I don't know if I think, because I think the difficulty I'm having, and maybe I'm not going to answer your question, but the difficulty I'm having is that I don't think under Iowa's system of post-conviction relief, the PCR court is making that ultimate determination of, we're going to dismiss the count, or you're going to stay the way you are now. It's going to remain affirmed or whatever. The remedy is a new trial. And so if you can't meet the preponderance test that is reasonably likely, either one, that there's going to be a different outcome, or, you went to plead guilty, whatever test you choose, it's still a probability.
In a new trial, hypothetical new trial in this case, couldn't the state put on the testimony of the police officers as to what BC said right at the time?
I see my time is up. May I respond? I'm trying to think whether in PCR, what the rules of evidence are. And I think the rules of evidence apply, because it's a civil case. If it fits within
The excited utterance.
cited utterance or an exception.
And
I
in-
certainly think you can, but I think even better is you have the CPC interview potentially. If I could sum up really, really quick. I totally disagree that our existing case law precludes any type of PCR from a guilty plea. We have a Court of Appeals decision that says, based upon motion for a new trial and for challenging the guilty plea, it does. This court has not said so, other than in Alexander, where I would submit that you did not just throw it in as dicta, that it has to mean something, otherwise that litigant had no opportunity. Thank you.
Thank you as well. The case of Schmidt versus State of Iowa is now submitted, and we'll hear the arguments in State versus Jonas.